This is On Bankruptcy, brought to you by the American Bankruptcy Institute. For those who have paid for the optional CLE, be sure to note the CLE code that will pop up throughout the presentation.
Welcome to the November episode of On Bankruptcy, a monthly discussion and analysis of recent cases and developments in the bankruptcy world produced by the American Bankruptcy Institute. This program will give you 1 hour of CLE credit in states where it is pre-approved. My name is Charles Tabb. I'm the Mildred Van Voorhis Jones Chair in Law Emeritus at the University of Illinois College of Law. I also am of counsel with the law firm of Foley & Lardner, LLP in Chicago, and I'm your host for On Bankruptcy. We're very fortunate today to welcome two distinguished guests, Judge Jeffrey Hopkins from the U.S. Bankruptcy Court for the Southern District of Ohio, and Dan Moss from Jones Day in Washington, D.C. Judge Hopkins was appointed to the bench in 1996. He received his J.D. from the Michael E. Moritz College of Law at The Ohio State University and graduated from Bowdoin College, did I say that right? With a dual degree in government and legal studies and anthropology sociology. At Bowdoin, he was elected by the faculty to give the commencement address at graduation, and he received the Class of 1868 award for that graduation speech. After law school, he served as law clerk to the Honorable Alan E. Norris on the United States Court of Appeals for the Sixth Circuit. Following his clerkship, he became an associate with Squire Sanders and Dempsey, LLP, specializing in complex commercial transactions and business litigation. In 1990, he was appointed as an assistant U.S. attorney and later became chief of the Civil Division for the Southern District of Ohio. Judge Hopkins is a past president of the National Conference of Bankruptcy Judges. Chief Justice Rehnquist appointed him to the Federal Judicial Center's Education Committee for Bankruptcy Judges in 2002. He was also appointed to the Advisory Committee on Bankruptcy Rules and to the Judicial Branch Committee by Chief Justice Roberts. Currently, Judge Hopkins is active in many civic and charitable organizations in the Cincinnati area. He formerly served on the boards of the ABI and the ABA Business Bankruptcy Committee. He's a fellow of the American College of Bankruptcy, was an adjunct professor at the University of Cincinnati College of Law. In 2010, Judge Hopkins received the William K. Thomas Distinguished Jurist Award from his alma mater, the Ohio State College of Law. So welcome, Judge Hopkins.
Thank you.
Our second very distinguished guest is Dan Moss, a partner at Jones Day in Washington, D.C. Dan earned his bachelor's degree from the George Washington University and his law degree from Cornell. After graduation, he clerked for the Honorable Lawrence S. Margolis, a judge on the U.S. Court of Federal Claims. Last year, Dan was honored to be selected as one of the ABI's 40 Under 40, which recognizes insolvency professionals who are committed to the highest standards of achievement at work and in their communities. He also was named a 2017 National Law Journal DC Rising Star, which identifies top legal talent under the age of 40, and was selected by Washingtonian Magazine as one of Washington, D.C.'s best lawyers for bankruptcy in 2018. Dan recently served as co-lead counsel for the Official Committee of Unsecured Creditors in the Toys R Us Property Company 1 Chapter 11 cases and the Peabody Energy Chapter 11 cases. Dan played a significant role in the City of Detroit's historic Chapter 9 case and was a member of the team that represented Chrysler in the sale of its assets to Fiat. Dan, welcome to On Bankruptcy.
Thank you.
Today we will discuss 4 topics and cases. For our first topic, we will go back yet again to fraudulent transfer country, a topic which it seems in some manner we explore almost every month on this program. As I'm sure our listeners know, for any avoidance action, there are 2 parts. First, as a necessary predicate, of course, is that it has to be avoided. Then, assuming avoidance, is the recovery part, which, of course, is what actually brings assets back into the estate. A recent Florida bankruptcy case, Yip v. Google LLC, In Re Student Aid Center, Inc., raised an intriguing and important question about the connection required between the avoidance and recovery parts. In a nutshell, the problem in the Student Aid Center, or SAC, case is this. Assume the trustee avoids the transfer as fraudulent in a lawsuit against the initial transferee. Subsequently, trustee sues a subsequent transferee for recovery. But the subsequent transferee cries foul, saying, no, I was not a party to the predicate avoidance action. I get to relitigate the entire question of avoidance. The trustee says, well, you must be kidding. I've already avoided it. All that's on the table against you, Mr. Subsequent Transferee, is the recovery issue. Who wins? Judge Laura Lisakoff says, quote, they are both right. Well, now how can that be? Well, what the judge solomonically concluded is, first, the trustee is not required to reprove her case in full on avoidance against the subsequent transferee in seeking avoidance. That's where the trustee is right. But secondly, the subsequent transferee is not necessarily conclusively bound by the prior avoidability judgment to which was not a party. Instead, they have the right to raise non-avoidability as a defense, and that's where the part with subsequent transfer is. So this should be interesting. Our second topic will again visit old waters, the dischargeability of student loans. This time, though, don't worry, we're not diving back into the murky undue hardship well. Instead, we're going to tackle a critical scope question, which is the extent to which private student loans are within the 523A8 discharge exception at all. Now, by private loans, I'm referring first to ones that are not made or guaranteed by the government, and secondly, those that don't fall within the ambit of qualified education loans under the IRC guidelines. So, looking at the statutory detail, another way to describe the issue is this. What is the scope of 523A8A2 as distinct from subsections A8A1, which is the government loan subsection, or A8B, which is the qualified education loan subsection? In a very significant holding, Crocker v. Navient Solutions, In re Crocker, the Fifth Circuit became the first court of appeals to squarely hold that 523A82 does not apply broadly to private student loans. So if a private for-profit student loan lender wants to fall within the protection of 523A8, under Crocker, it's going to have to jump through the carefully circumscribed and extremely limiting hoops of 523A8B in the associated IRC statutes and regulations, which they definitely do not want to do. The reality is, says the Navients of the world, they do not want to comply, and indeed their business model typically would not comply with the demanding strictures of A8B. So Crocker's a rare big win for student loan debtors. For our third topic, we have dueling opinions discussed on consecutive days in Rochelle Daily Wire on October 17th and 18th. Factual scenario and accompanying legal issue is pretty straightforward, but the resolution is anything but. Okay, here are the basic facts. Debtor files 13. Timely files the creditor matrix, but unfortunately the debtor inadvertently omits a creditor from the matrix. So, with the clerk of the bankruptcy court sadly lacking the gift of omniscience, the omitted creditor does not get notice of the bankruptcy case, and the creditor, also lacking the gift of omniscience, doesn't timely file a proof of claim. However, they learn about the bankruptcy case, hat in hand, go to the bankruptcy judge and ask in her kind beneficence to let them file a claim late. Debtor, of course, would like that too, so the claim can get dealt with and discharged in the bankruptcy case. The technical legal question before these judges was, does Bankruptcy Rule 3002C6A, as amended in 2017, empower the court in its discretion to grant the creditor leave to file a late claim? In In re Somerville, Judge Michelle Harner said no, but in In re Vanderpool, Judge Elizabeth Brown said yes. As we'll discuss, the resolution turns on how one interprets the provision in the bankruptcy rule that late filing is permitted if notice was insufficient to permit the creditor to timely file his proof of claim because, quote, the debtor failed to timely file the list of creditors. We'll talk about what does that mean. Judge Harner, there was no escaping the fact she thought that list of creditors was filed, so rule allowing late filing not triggered. Judge Brown, on the other hand, took a different view and said, well, filing a list means you file a complete list, including all creditors, including the omitted creditor, because it's certainly little solace for the omitted creditor that the debtor listed other creditors who did get notice of the case. Thinking about cases like this reminds me from back when I was on the Bankruptcy Rules Committee eons ago just how hard it is to write a rule that captures just what you want, no more and no less. Certainly a reasonable argument that the rule reads just like Judge Harner read it. It's what it seems to say. But then again, as we'll talk about, that doesn't really make any sense because from the perspective of the omitted creditor, they're just as negatively affected because they're not on the list, whether there's no list filed or list filed without their name. Either way, they don't get notice and don't find out in time to participate in the bankruptcy case by filing a proof of claim. And so we'll have to see how that shakes out. For our final topic, we'll do a preview of the Supreme Court case that by the time you hear this, was argued on November 13th, of course, Ritson Group, Inc. versus Jackson Masonry. As we're taping the show, be aware the case has not yet been argued, so we can't talk about, well, what was said at oral argument and the like. But by the time this airs, oral argument will have occurred. In Ritson, of course, the Supreme Court will tackle the question of what constitutes a final order in a bankruptcy case. Bankruptcy finality, as you undoubtedly know, is tricky because you have the one big overarching case, but there are a lot of distinct proceedings within the umbrella case, some of which, depending on the terms, can be brought up again and again without the same exact kind of res judicata effect that a normal general civil litigation would have. In a sense, then, bankruptcy embodies the reality of the phrase which was used in the Supreme Court case, "It ain't over till it's over," attributed to Yogi Berra. Now, trivia point for extra credit. What was Yogi referring to? And the answer was the chances of the 1973 New York Mets to rally and win the pennant, which they did. But unlike the Washington Nationals we see from our show, they lost the series in 7 games that year to the Oakland Athletics. In Ritson, the disappointed creditor had moved to modify the automatic stay, but relief was denied. Creditor did not appeal denial right away within the time required to appeal a final order. Later, when it did appeal, the appeal was dismissed as untimely. So the question is going to be whether denial of stay relief is or is not an appealable final order. So the Supreme Court will be taking another stab at defining the meaning of what constitutes a final and appealable order in bankruptcy. In 2015, the court had held a bankruptcy court order denying confirmation of a Chapter 13 plan was not an appealable final order in the case of Bullard versus Blue Hills Bank. In Ritson, though, Sixth Circuit said denial of a lift stay motion is final. So one denial not final, another denial is final. I mean, is this just a situation in illustrating the saying by Ralph Waldo Emerson that a foolish consistency is the hobgoblin of little minds? Or is this more aptly captured by Gertrude Stein's famous saying that there's no there there? And as another trivia aside, I wonder how many people knew, I did not, I had to look this up, Gertrude was talking about her birthplace of Oakland, California. So regardless of whether you favor Yogi or Emerson or Stein, hopefully the court in Ritson will give us a clearer sense of what is and what is not a final and appealable order in bankruptcy. All right, on our first topic, then, we're going to talk fraudulent transfer avoidance litigation, which must be important because it comes up every month. In the Student Aid Center case, bankruptcy judge Laura Liskoff posed this question. She said, quote, "Does a trustee have to prove the avoidability of a transfer in every action against a subsequent transferee, even if the trustee has avoided the transfer already?" We'll turn to Dan Moss to get us started. So Dan, which of the following is the correct answer to Judge Isikoff's question? Yes, trustee has to prove avoidability in every action versus subsequent transferee, even if it's already avoided it, or no, trustee does not have to prove it again if they already avoided it. So what's the right answer?
Well, the answer is no, at least in the Southern District of Florida.
Yep, okay. And so the judge gives the no answer. It's not inescapably required as part and parcel of every action against the subsequent transferee. Why? What was the court's reasoning in terms of what is going on there?
So, relying on International Administrative Services, an 11th Circuit case, for the interpretation of Section 550, Judge Isikoff notes that nowhere in the plain text is there a requirement, or even a suggestion, as she noted, that the transfer must always be avoided in the action. Further, again, citing the International Administrative Services case, she notes that judicial economy and efficiency is best served by not requiring the same, which that makes sense. Mm-hmm. Further, the judge also did note that it reduces and minimizes litigation costs.
Okay. Well, so how persuasive are those reasons? I mean, that makes sense?
So I think the textual side appeals to me.
Yes.
What I sort of have questions about, particularly in light of the ruling, not to jump ahead, that yes, Google gets discovery into certain pre-petition transactions that they were not a party to in the initial underlying avoidance, is the minimization of litigation costs, judicial efficiency, time, and delay. Because I think that when you put a burden, as this court did, on a party to prove a defense, then they're entitled to discovery, which then creates a whole separate scheme. Which I think that's why this is an interesting case, because this is really a discovery dispute. This is not about adjudicating whether or not the underlying substance is true. It's about what someone has to be able to seek with discovery.
Yeah. And one interesting thing that came up in part of the 11th Circuit authority the court looked at and drew from dealt with actually a very different question, which is the situation if the trustee has not already avoided the action against any of the transferees and then seeks recovery against the subsequent transferee, are they then allowed to try and prove avoidance in that action itself? What, in that situation, is the outcome?
Well, in the normal circumstance, you can sue a subsequent transferee, and then the burden first rests with the trustee to prove the initial avoidance, and then, obviously, the defense is able to be brought as the subsequent transferee defense.
Okay. And that decision by the 11th Circuit, it's like the court found this relevant. So I think before we get any further into the sort of the reasoning and legal analysis, it's probably helpful for our listeners to have a feel for the very crazy facts in the Student Aid Center case. Millions of dollars on the line. So Dan, kind of walk us through basically what was going on here.
This is where I think a timeline is very useful. And if you look, February 2016, the Student Aid Center files for bankruptcy. A year more later, July 2017, the Chapter 7 trustee brings an adversary proceeding against 3 parties. One, a gentleman named Alan Alvarez, who's the father of the debtor's principal and president, and then 2 entities allegedly owned and controlled by Alvarez, Deco Media and SAC Group. In August, Alvarez, not the entities, files a pro se defense. The entities file no pieces of paper. In January 2018, default judgments entered against the 2 entities, totaling over $6 million. In March and April, Alvarez and the trustee have an exchange of papers and motions, and then, at least as was reported by Judge Isikoff, a lengthy summary judgment hearing occurred where the trustee and Alvarez presented evidence, provided testimony, and it appears as though, from both the trustee and the judge's perspective, questions were raised with respect to Alvarez's potential defenses. It doesn't seem that Alvarez actually asserted any defenses, but questions were raised such that there was probably a probing inquiry given the due process implications with an individual. Makes sense. In May of 2018, the court granted the trustee's motion for partial summary judgment, and then ultimately it was entered in full against Alvarez. So in this instance, then we have all 3 entities, one of which appeared and was heard, 2 of which had default judgments.
So 2 defaults have summary judgment against the initial transferees. Then what happens?
Well, then, almost 8 months later, the trustee turns around and sues Google as a subsequent transferee for about $4.2 million of the $6.3 million that was judgment against the other entities.
And Google, of course, I mean, you're always going to raise a 550B defense, but they want to do something more than just that. What does Google want to do?
They wanted discovery into, this is what makes this case interesting, is that it's a discovery dispute and it's an opinion on the scope and availability of discovery, which triggers, obviously, rules outside of, the bankruptcy code. Given the wide latitude that's given under Federal Rule 26B1, any evidence that's admissible with respect to a party's defense is entitled to be discoverable as long as it's not privileged. So Google's saying here, I had a pro se defendant who maybe didn't make the best arguments, and I have 2 other defendants who didn't even appear or make any defenses whatsoever, and default judgment was entered. And Google said, we should be able to assert a defense, just like if you had sued me for the first time, before having gotten these initial transferees, I should be able to raise the same defense because this was effectively an inadequate defense put forward by the initial transferee.
So it's interesting. So we have a situation, but of course, where the subsequent transferee wants to effectively relitigate the avoidability questions, and that's what their discovery was going to. Of course, if they're not allowed to litigate, if they're bound by the avoidability, then it's got to be quashed. It's like irrelevant to any legal issue that's on the table in the court. If all that they're doing is the recovery, it's not a problem. Okay.
And that's the trouble.
Yes, of course.
Because it's going to really drive up the cost of litigation.
Absolutely.
And you're going to see, and look at the imbalance here. You have a panel trustee who's fighting against the Goliath. And so the Goliath is going to bury them in discovery, or him or her in discovery.
And that's the worry. And that's why, when this case came out, as we were talking before, it had never honestly occurred to me that they could relitigate it in this way.
Well, what's raised judicata? What's collateral estoppel if not that?
Yeah,
Which is why the interesting part of this is the burden then just flips to Google or whoever the purported subsequent transferee
We'll talk
is.
about that. So, in this case, we have a situation where, recall I said in the intro that Judge Isikoff said, they're both right. Obviously, the way the trustee is right is they're not required always. There's one argument Google was making is they always, if we were not party to the avoidance, trustee must always prove avoidability in the action against us. Judge Isikoff said that's not necessarily right. But they also said Google's right. What had Google argued then, and what was the way then in which Judge Isikoff said Google, the subsequent transferee, was right?
So 550B1, it allows the subsequent transferee to defend themselves that they lack knowledge of the voidability, and that such knowledge was lacking because, among other things, the initial transfers were not voidable. And if they weren't voidable in the first place, then there's no action. So in this instance, for Google to be able to say and prove that they lack knowledge of the voidability, they have to have discovery into that entire process. Judge Isikoff is not saying that you have to re-litigate the actual substance and merits, but they're saying that Google has the ability to at least, look under the hood.
But who's the burden of proof ultimately rest with? I would think
For the defense.
Yes.
Yeah.
And so,
Google. Yeah.
so basically what we have, the upshot of this is the Google does get discovery, as you said, because the avoidability at some level is an issue, because you said 550B was like not going to be triggered if it wasn't actually really even avoidable. How could they have knowledge of something that didn't actually exist? But then you have the concern, as you said, Judge, that now the Googles of the world can bury this poor panel trustee.
Well, this is where the risk didn't worry me as much, because Google got a half loaf. In the instance with respect to the pro se litigant who appeared and there was a probing inquiry, in that instance, the burden has shifted entirely to Google in order to substantiate, yes, there's discovery issues, but the res judicata argument, it's sort of saying, well, someone was there, someone presented a case, and even if they present a bad case, that's just the way the cookie crumbles. With respect to the two defaulted, the court seemingly, without ruling on it, specifically saying, I'm not ruling on that, it has the ability to let more. That does not fit the 550 prerequisite that you must avoid the initial transfer.
And that raises, I was thinking this through as sort of a litigation process strategy matter. That's an interesting problem. Let's say you're the panel trustee. Let's say you bring an avoidability action against an initial transferee, and it's looking like they're going to default. This is basically saying that's like bad for you, right? If it's good you won that one, but if you have a well-funded subsequent target you're going to actually get some recovery from, like Google, you're essentially going to have to relitigate it against them, especially the court seemed inclined if it were a default judgment initially. So then I'm thinking, and I'd like to ask each of you, as a litigation strategy, then should the trustee routinely in the avoidance action join any subsequent, because then they will be bound, right? You'll then clearly have a collateral estoppel ruling. The judge here didn't say whether there was or not, but you can't really get collateral estoppel against someone who's not a party to the earlier proceeding. Or do you say, hey, fine.
But that raises a point that Dan made earlier when we were privately talking, and that is, you don't know until you get into discovery. You don't know who the subsequent transferees are.
You just have to get your avoidance in. You have, as you were saying, Dan, you have different statutes of limitations. You've got to get the avoidance done. You know who the initial transferees are. So you've just got to get that done. But I think, so Judge, what do you think the takeaway is from this case? Ultimately we have the subsequent transferee is not incontrovertibly bound by the initial avoidance. They are allowed to raise it as a defense, as you said. What's the takeaway?
Well, I've said one, you're going to drive up the cost of litigation. You're going to have the Goliaths of the world coming down on the Chapter 7 trustees. I don't know. I just think it's going to be further litigation if you can't use that affirmative, avoidable determination in subsequent litigation when you're after the immediate parties.
Dan, what do you think? What's your takeaway from this case?
It's an interesting case, in that this is all kind of dicta at the end of the day, because it's about a substantive issue in the context of a discovery motion, which is sort of, there may be questions about the authority behind it, but at least where it sits now, if you have a defense, the burden may rest with you, which then justifies your discovery requests.
Yeah.
But getting default judgment, I'd be wary on that one.
It is interesting, because usually, of course, you're thrilled to get a default judgment. You won without having to do anything, but it sounded like you're worse off with that. Certainly the one that was more litigated. Okay, let's move for our second topic to back to student loans, but we're going to talk about something different this time. In the Crocker case out of the Fifth Circuit, we're going to look at the scope of the exception. And what we're going to be looking at, there's I think, a widely held belief. I know I sort of had that intuitive knee-jerk sense that the 2005 BAP-CEPA amendments made private student loans non-dischargeable, just like government made or insured. But in fact, as the Crocker case will show, it is a much narrower play than that. So, Judge Hopkins, let's get started. So, I think this one we really need to have a feel for the facts so we know exactly what the loans were for, what the lender was like, so we can then tease out the legal issues.
Sure. You had two debtors here. Both had filed Chapter 7, one in Virginia and one, Mr. Shabazi in Virginia and Mr. Crocker in Dallas. Mr. Crocker is being hounded by the Navient, who is a private lender, for the recovery of its student loans, which purportedly were not discharged in bankruptcy. Mr. Shabazz.
What were his loans for?
Mr. Crocker's loans were for borrowing money to study for the bar. It wasn't necessarily associated with his work.
It was the bar review course.
Exactly.
Yeah.
So
Okay.
he borrowed $15,000 from Navient in order to have that happen.
Oh.
Now, Mr. Shabazi, on the other hand, borrowed money in order to go to a technical school in Virginia. So he comes over to the Fifth Circuit, and there's a class action actually being pursued. A declaratory relief and damages are being pursued or sought against the creditor here who's continuing to collect against them. And so, we end up in court, and it goes up on appeal to the Fifth Circuit, and the Fifth Circuit basically holds in favor of the debtors here, finding that the two loans were not subject to 523A.
And it's a very important, and I think often we sort of just assume with a student loan or educational loan that 523A8 applies. But this opinion is a good primer to kind of work through what it doesn't apply to. I mean, you think like every educational loan is not going to fall within the scope of the exception. If you break down the rule, there's basically three possibilities. There's A8, A1, A2, and B. So A8, A1, A8, A2, and A8B. And for the exclusion from discharge supply, it has to fall within one of those three categories. Okay, Judge, you get to walk us through the statutory path. 523A8A1, what does that cover?
It covers educational benefits, overpayments of or loans made or insured or guaranteed by a government unit. And Judge Southwick, my apology, in the Fifth Circuit describes A1 as applying to loans, etc., in which a government unit or nonprofit institution had a defined role. There are three requirements. The debt must be an educational loan or an educational benefit overpayment, and courts look to the purpose of the loan in order to determine whether it's an educational loan or loan, and it must come from a loan program, the third prong of that test.
So for Evan Crocker, Michael Shabazi, A1 does not apply to either. Why?
Because both loans were obtained from Sallie Mae, which assigned its loans to Navient, and Sallie Mae is a nonprofit corporation. I'm sorry, for-profit corporation. Had it been nonprofit, it would be non-dischargeable. And so it didn't qualify for the governmental nonprofit
so if it's not,
exception.
So this is like, and this will be,
This
for the
is heavy
Navients of the world,
stuff,
this is, no, but this is important though, like for the Navients of the world, they can for sure write off A1.
Yes.
I mean, there's no possibility because they don't qualify as either government or nonprofit.
They are a for-profit corporation.
Exactly. Okay. We'll skip A2 for a minute because that's what the case is about. Let's get rid of A8B next. Okay. This was the one that was added in 2005. It's one that's sort of in common understanding. People thought, well, this is what made private student loans non-dischargeable. What exactly does subsection B cover? And this is tough sledding.
It sure is. So let me just walk you through it. I'm going to have to rely heavily on my notes here. So subsection B covers any other qualified educational loan as defined under the IRS code, 221A1 or D1 for those of you who are interested. So the requirements are threefold. The obligation must be an educational loan.
Okay.
It must be a qualified educational loan as defined under the IRS code.
So we have this cross-reference to the
Yes.
Internal Revenue Code
Yes.
and rules and regulations.
I need
Okay.
a Venn diagram.
yeah, exactly.
Which are incurred on behalf of the taxpayer, someone related to the taxpayer, which are paid or incurred within a reasonable period of time before or after the indebtedness is incurred, and which are attributable to the education furnished during a period which the recipient was an eligible student.
Okay. Now, and then to drill down further, we'd have to get down in the weeds on the Internal Revenue Code reference
Yes.
and stuff. But generally speaking, sort of stepping back a little, what would be some sort of common reasons that our listeners might be able to understand without having to whip out their Internal Revenue Code?
Right.
Why a loan, it's an educational loan, but would not qualify under B? And this is going to be important for the Naviance. What are some of the reasons why it would fail?
There are instances where the courts have determined it's not a loan at all.
Okay.
There's a decision out of Indiana, the Oliver decision by Judge Carr over there, where the university, Ball State, had given the debtor the ability to continue to have an education even though the debtor had dropped out. And so the debt that was left over when the debtor didn't pay through the student loans that they received outside were not part of what the Ball State was trying. They were just simply trying to get recovery of what the tuition payments had been and missed.
So that would be one. Oh, and let's
Not
talk
alone.
Not alone. Let's talk about our debtors in these cases. Evan Crocker, bar review prep guy. Why is his not covered? And Naviance not making any arguments covered by A8B, and of course it's not even an issue. Of course it's not covered. But again, so our listeners have a sense of the statutory sort of superstructure. Like, why didn't Evan Crocker's bar review prep loan qualify?
He wasn't attending an educational institution. He was borrowing it to study for the bar, as we sometimes.
And that mixes you. Okay, but Michael Shabazi was attending an educational. He was
Yes.
going to tech school. This is good. He's going to get a job.
Doesn't qualify. It doesn't fit with under Title IV of the IRS code. So it's not an institution covered.
It's not a covered institution. And the reality, and you sort of step back, one thing I'll say to our listeners, one reason Crocker is important is lots of the private for-profit loans that are being made do fall outside of the ambit of what A8B covers. The kinds of loans people would think would be covered, those would be loans that would be under A8A1, but then they have to be government, made or insured, or nonprofit. If it's private and you're paying for somebody to get a bar review prep course or go to an unaccredited tech school, because a lot of the push has been for these kind of unaccredited schools and things like that. That's where they're making a lot of their money.
That's right.
And there are lots of limitations on, because if you're going through an accredited school that's covered under the Internal Revenue Code rules, the lender has to play nice. There are rules that they have to abide by, and they don't want to abide by those rules. It's not their business model.
No question.
Okay, so we're left with A2. Now this is again tough sledding. As I said, what exactly does A8, A2 say is covered?
So wedged between the two loan provisions,
Yes.
little I, AI, and A2 or A3 is or B, I'm sorry,
Yep.
is this A2, which deals with obligations for repaid or received as an educational benefit, scholarship, or stipend. And so the court in and Croker said it's not a loan at all. The courts they didn't use the term loan. It's an obligation incurred, which is different.
So it's interesting. So we have an obligation to repay funds received as it has to be either an educational benefit, a scholarship, or a stipend. Okay.
Right.
Now, Navient didn't even argue for Crocker or Shabazi that it was a scholarship or a stipend. Why not?
Well, because it
wasn't.
because it wasn't a loan. Put very simply.
So what they're basically, because this was not like a scholarship. I mean, Evan Crocker didn't get a scholarship to like study for the bar, right? And so they instead were trying to look at the third category, which is educational benefits. So, and this has been the play in the cases. What the Naviants of the world are trying to do is to give a capacious interpretation to educational benefit. Basically, any obligation, they're basically saying any loan for an educational benefit whatsoever, and they're freed from the strictures of AAB and all those types of rules. They're not government or nonprofit. Doesn't matter in their view, because they say with the 2005 amendments, obligation to repay an educational benefit covers everything.
That's right. Any sort of debt associated with someone going to school.
Any kind of an education. And it's certainly a benefit to not flunk the bar, for example, or be able to
Kind
get
of important if you want to be a lawyer.
If you want to be a lawyer, it comes in super handy. Okay. So Navient's argument in a nutshell as to why these were obligations to repay educational benefits was what?
Because it inured to the benefit of the debtor in order to be able to get an education. So it's very broadly defined. Anything that can be construed as a benefit should be non-dischargeable.
And so, sort of look, and this is why it's such an important case, because if the court had agreed with Navient, then basically any loan of any sort that would benefit someone educationally. I mean, if you wanted to loan me money, $50, so I could buy a book to read up on Irish whiskeys and educate myself, and then I didn't repay you, that would fall under this.
No question.
Right? It's like, I'm benefit. I know the difference in with this kind of whiskey and that kind of whiskey. That's good. It's like, okay. Fifth Circuit holds what, though, with regard to the scope of A8?
Well,
A2?
the Fifth Circuit uses a series of statutory interpretations. Which
This could totally be like, you could teach an entire course
Absolutely.
in statutory
You could
interpretation.
create a course.
You could create a course out of this opinion.
On
It covers them all.
Well, first, using exceptions to discharge should be narrowly construed.
Okay.
And that is basic bankruptcy law from the very foundation. And then it uses the surplusage doctrine. You know,
What's the surplusage point? This is a very important part of the opinion. What was their point there?
so loans in both B and in AI, the small AI, but in the middle part, it says benefits and stipends and scholarships, obligations created for those things or associated with those things. So that's very, very different. And the court said an obligation of that sort using this Latin phraseology, help me out.
I remember once talking with a student who had been a Latin teacher. It's like, he said, I asked him how to pronounce it, and he said, well, Professor, you realize no one's spoken Latin in several thousand years. But the nascitur associus,
Okay.
I just made that up,
Yeah.
but you can't prove me wrong.
Right.
Basically.
Yeah. So essentially, the court said when you're dealing with this kind of debt associated with that, it has to be akin to that. It has to be a stipend, a scholarship, or something very similar to that you are receiving in order to get an education. That's not
And
what
it's just
happened now.
repaying. And then they were saying, look, if we took Navient's basic premise, then essentially we could just go delete A1, we could go delete B, because everything would fall within educational benefit. All you would need, is an obligation to repay. It doesn't have to be a loan, it could be a loan, not. It's like everything that's an obligation to repay. And so, as you said, they're sort of making the point, it cannot be that it was intended to cover the entire universe. That educational benefit, as you said, must have a meaning under this nascitur associus doctrine, similar to a stipend or scholarship, and it's just an obligation to repay. That being the case, then why?
Let me give you an example.
Yeah.
Okay, so I work for a company, and my company gives me money in order to, or pays my tuition. That, I think, qualifies under this and would be non-dischargeable if I were to walk away from that debt.
But Navient loan and Evan Crocker money to study for the bar review, not. So why does that not qualify? I mean, under what was lacking here for Navient, given the Fifth Circuit's theory with regard to the bar review prep course of the unaccredited tech school?
Well, you had a loan here. This was clearly a loan, which took it outside of this language, the court said.
Yeah.
And so in order to be a non-dischargeable on A2, you have to show that it is it's a benefit for education.
And so, sort of thinking of the upshot, then these private lenders, if they want to fall within it, they're going to only be able to get accepted from the discharge under A8B. And as you talked, That has lots of limitations and strictures. Certainly doesn't apply to unaccredited tech
Right.
school loans or bar review prep loans and things like that.
Right.
So it's a very significant holding. Dan, what do you see as sort of the important takeaways from a case like this?
Oh, I just think it's important because look, education is very expensive. I mean, and that's not going to go away. You know, I mean, medical costs and education prices are going up. So, I mean, I see this as something that could really affect a lot of people going forward.
Yeah, and if the holding
Especially since these lenders are in the market in a big
Absolutely.
way, and you don't have the government stepping up as it used to as much.
Absolutely, very good point. Our third topic seems like a technical part, but it's a very important problem with regard to the operation of Chapter 13's. Ask the basic question: a creditor who is omitted inadvertently from the creditor matrix, so they don't initially find out about the case, do they get to file an untimely proof of claim or not? And it's a fun topic because we have dueling opinions. Well, I mean, they didn't know of each other, so they weren't dueling, but they come out opposite. So, Dan, basic fact situation in a case like Somerville, Judge Harner's case, Vanderpool, Judge Brown's case, what's sort of the basic play of what was happening on the facts?
Pretty short and simple. A creditor, for whatever reason, is not included on the creditor matrix, which is supposed to be a reflection of the schedule. And the creditor
Happens all the time.
and such creditors, the address is incorrect, the name is completely omitted, there's a typo.
So, but the debtor does file a creditor matrix.
Yes.
They just don't file a complete
And accurate. Yes.
And you're saying, never seen this before. Only in like every case. No.
Happens every time. That's right.
Yeah,
There's always someone left off.
Yeah. Okay. And so,
Intentionally or unintentionally, but sometimes it's intentional.
yeah, I believe that. But in these cases, then, before the Chapter 13 plan had run its course and everything, the creditor somehow miraculously finds out about the case, goes to the judge and says, Judge, can I file now? I missed the bar date because I didn't know about the case, because I didn't get notice of the case, because I wasn't on the creditor matrix, and the clerk didn't send me notice of the case, but I know about it now, and I want to file. Okay, before we dive into the particulars of the rule, let's talk about it. It's always important. I always talk with my students, like, why does something matter? What if we don't let the creditor file a proof of claim here? What are the consequences for the creditor, for the debtor, for other creditors? I mean, what are the ramifications of this? So, you know, in a Somerville holding, like, if you say, no, you can't file, what happens? And then we'll contrast that with what the situation will be in Vanderpool.
Well, it's pretty stark in that under one circumstance, the plan doesn't then provide for the debt, therefore the debt is not discharged. And in this instance, Judge Harner specifically said, this particular creditor's claim is not discharged, and after doing some analysis, it showed that, in fact, the claim will likely survive and be assertable in 3 to 5 years, you know, once the plan is complete. Right. So in that instance, you know, the detriment is there's not a real fresh start or ultimate discharge.
That's bad for the debtor.
That's right.
But it's interesting, both courts, like, actually even talked about it, said, but creditors want to get in on this too.
Sure.
Right? Why?
Well, they get paid. They get
There
paid
you
something
go.
Time is money.
Yes.
Money now. I mean, I remember, you know, talking to the creditors, like, just pay me some money now.
But
Well,
It's
Judge
like
Harner
saying,
makes
hey,
a
in
good
5
point.
years it's going to be non-dischargeable. They're like, 5 years? They may be living in outer Mongolia. I mean, they're going to pay me money that a court trustee is going to send me money every month,
Right.
or not.
The horns of the dilemma here is that Judge Harner, in her opinion, says, you know, had they filed a claim and it had been disallowed because it was late, then
Yeah.
the discharge impacts them. 1328, the
And
debt's
it is
gone.
provided for by the
Right.
plan.
Right.
That's right. That's right.
That's a really important
But I
point.
also see where Judge Harner's sort of concern here is that at some point in time, a late filed proof of claim 3 years into a case could completely upset the creditor mix and would be unfair to those creditors who did participate. Which is why I think the facts of this case,
Exactly.
in comparison, matter a little bit.
Because they didn't know, they didn't find out about the case in time to meet the bar date, but they found it pretty soon thereafter and just wanted to get in the game. And so, but if they don't, they're not going to be discharged. They're not going to get paid now. And from the debtor's perspective, not only is it not going to be discharged, like it's not going to be paid down at all by payments in the case. So the creditor is invoking what rule, Dan, to try and get permission.
This is Bankruptcy Rule 3002 C6A.
There you go.
Very good.
Which, as we'll discuss, was recently revised in December of 2017, with at least the apparent thought, if you read all the commentaries, to expand the ability to have a late filed proof of claim. Before, there was a set time period from the petition date out. Now it was pegged off of the order actually allowing the proof of claim to be filed late.
Right. And this is, I mean, it's interesting, Rule 3, just sort of a little background, or listeners may know, Chapter 11 gets to play under the General Rule 9006. I think it's just a general excusable neglect standard. But 9006 carves out 3002 and first 7, 12, and 13 say you got to jump through the 3002 hoops, which are not as capacious as just excusable neglect. Just go to the judge with your sob story, talk him or her into it, you're okay. As amended in 2017, what are the specific requirements in 3002 C6A?
It boils down to two elements.
Two elements.
Insufficient notice, which clearly occurs, particularly in these facts. And the second, which is that the debtor failed to timely file a list of creditors with the names and addresses as required by Bankruptcy Rule 1007, which necessarily references Rule 521, that mandates a debtor file a list of creditors. Now, I have to admit I had to go back and look because I always just assumed that it's a complete and accurate list. You know, from my Chapter 11 world, a lot of time is spent on developing these schedules.
Right.
So this was something that I think was obviously not necessarily as implicit as certain practitioners deal with.
Yes.
In fact, they had been litigating up until the point of the bankruptcy, which is odd. I mean, I think the creditor had gotten a judgment even.
Yeah, yeah. And so, but it's interesting, the rule, it's interesting how it's written. It says, like I say, insufficient notice to be able to file a timely proof of claim because, and he said the second point, debtor failed to timely file the list of creditors required by Rule 1007. So what the courts are fighting about here is the second element. That is, was the insufficiency, notice the failure to be able to file insufficient because of the debtor's failure to timely file the creditor matrix list required by Rule 1007. Judge Harner holds what and says why?
She takes a very strict approach and says the list was filed. There's no requirement in the text or otherwise that requires it to be complete and accurate. Therefore, the satisfaction has been made and the rules literally do not allow any flexibility with respect to a late filed proof of claim because it may not have been timely noticed, but it was timely filed.
And so she says the second element says they have to have both and compares it to the rule about sending notice to foreign creditors. Says list was filed. Okay, Judge Brown in Vanderpool acknowledges this set of views on reading it, but holds the opposite. Okay, she held what?
She took a more, I'll call, practical approach and sort of said, look, we have to read the bankruptcy code in context. And she laid out a very interesting sort of timeline hypothetical scenario in a situation where a creditor would never file the list or the schedule, which, I at least reading it seems like that would be a unique occurrence.
Let me ask you a question. One intriguing point that Judge Brown makes is she invokes Section 521I.
Right?
Yes.
Judge, what was her point on there?
It's a new provision. 521I says on the 46th day, if you haven't filed a list, you're out. The case is dismissed.
Without any action. Just it's by default. That's right.
It's automatic.
You can come back for comfort, but the statute's very clear. It's gone.
So her point is that in such a circumstance, you could end up in this world whereby the case automatically dismissed, thus you never even trigger the rule. So she says, okay, fine. These all have to work
basically,
together.
in a sense, to make sure I understand, she's essentially saying, she didn't refer to Judge Harner's opinion, but she's basically saying if you take sort of a strict reading of this rule, it will never apply because the case would have been automatically dismissed on the 46th day. And so because of the failure to file the list, so there's no scenario in which the provision of 3002 would ever come to be.
It's interesting, I don't want to disparage, but the two maxims that both judges put up, I don't, you would know better than I don't know how often you find a case where there's nothing filed such that on the 46th day this rule would be triggered either.
Yeah, it happens because you have some debtors who are regular filers, and they just invoke.
Or the way they just jump in, try and stop the foreclosures.
Exactly.
Yeah,
That's what they're doing.
Just file
And so they
a
don't
face
do
sheet
anything.
petition and
Right.
yeah.
And the creditors are scared off enough they won't.
So come
foreclose.
day 46, the case goes bye-bye.
Right.
Yeah.
So in this instance, given that it is a possible scenario, Judge Brown lands on the complete and accurate side, which is it's great if you file something, but you must file that which is complete and accurate. Therefore, if there's no notice, that would allow some justification. Otherwise, why would there even be a rule that allows additional expansion of time? But this is where I think the facts are interesting. In that the creditor before Judge Brown had actually filed a proof of claim late, a month after the proof of claim bar date, but before the plan had been confirmed.
Right.
And then within 2 weeks of the plan being confirmed, filed a motion to allow a late filed proof of claim. At that instance, the creditor pool is not so set. In the other case,
And there's time.
there was no
And there's
creditor.
time, yeah.
There was no creditor action before the plan was confirmed, and in fact, it was months afterwards
Right.
that the creditor shows up and says, "Oh no, wait." So I could see.
We just found out about this case.
That's right. So I sort of see Judge Harner in footnote 15, I think it was, sort of articulated this concern that, well, what's to say 2 years down the road? The rule says what it says. So I sort of see like each one is recognizing the facts in front of them in the situation which the creditor has presented themselves to the court.
Let me just inject one piece. Marama, a Chapter 13 case,
Yes.
you all use it in Chapter 11. We're all
Yes.
surprised to see that. But, the Chief Justice there says, you have to have good faith in order to convert from 7 to 13.
Even
Where
though it
is that?
sounds absolute.
Where's that in the statute,
It's not.
in the rules? It's not.
Not anywhere.
So this could be that case, and Judge Brown could be vindicated in the end.
And it's interesting because, I mean, as you were saying, Dan, it makes sense to say that it feels like the thrust of 3002 here in this subpart is you should be allowed to file late if the reason you didn't file is because of a default in the debtor's filing of their list of creditors. The way the rule says is they failed to timely file a list, but it doesn't help the creditor if they filed a list that didn't have you on it. You're just as hurt as if they didn't file a list at all. Right? And indeed, since they filed a list, it won't be automatically dismissed on the 46th day. But it raises an issue. I mean, it sort of suggests either like the Rules Committee needs to sit down and scratch their head and try and figure this out, or maybe we just need a more general rule. I mean, it seems to me that this is an opportune scenario to defer to the wisdom and discretion of a bankruptcy judge. As you're saying, like, what are the specific facts in this case? Who's going to get hurt and
There's
why?
one view. I mean, look,
Yeah.
you could look at, has a plan been substantially consummated? To avoid, what Judge Harner's looking at with a
Right.
concern that you come in so late. In those instances, obviously,
Yep.
that would upset the creditor matrix
Right.
and expectations.
Right. Final topic. Let's give a preview of the Ritson case. What is finality in bankruptcy? Judge, let me just ask first. It seems like an obvious question, but it's the kind of thing, I think my students like, what difference does it make? Final, not final? Why does it actually matter what the answer is to what is a final order?
Because bankruptcy is a jigsaw puzzle. You've got lots of stuff going on, contested matters, adversary proceedings, all of which have meaningful consequences. And so if you adjudicate a matter to finality, you need to file your notice of appeal immediately, or you'll lose it under 8002, the rule, on 14 days to file your appeal.
So we need to know. But as you said, bankruptcy finality can be tricky. So, I mean, Ritson Group, in this case, I mean, they didn't, right? They had filed their motion for relief from stay. Judge says no. And they wait, and they file their proof of claim. Like, long time later, long after 14 days, they appeal, and they're kicked out.
Right.
It's untimely. So the specific issue then before the Supreme Court is what?
Well, the Supreme Court wants to know whether the motion for relief from stay is a final appealable order.
Denial of a motion for relief.
I'm sorry, denial.
No, yeah, and okay. Obviously, one would think that they're going to look at the Bullard versus Blue Hills Bank
Absolutely.
case, 2015 case. For those of our listeners who have forgotten what happened in Bullard, what was going on there? What kind of order was it? What did the court hold, and what was their reasoning?
There we were dealing with confirmation in a Chapter 13 case.
Okay.
And so the case had, there have been 4 amended plans filed by the debtor. over a year's time. And the final plan that he had filed, he was trying a hybrid plan under a very unique set of circumstances that only Massachusetts seems to operate under.
Right.
And so he was seeking to bifurcate a claim and then have it have extended period of payment after the Chapter 13 case had closed. Well, then the court denies the confirmation, and so he seeks to then take it up on appeal right away.
Right now.
Yes.
And they say, and the Supreme Court only holds no, not final, and why?
Not final because confirmation is a process that is, first of all, recognized under 157. It's a court proceeding, and it ain't over till it's over, according to Yogi Berra.
They get to use Yogi.
Yeah. So
you can file an amended plan.
He's filed an amended plan. It's not really a final appealable order until you have either dismissal of the case or confirmation of that Chapter 13
So
plan.
confirmation would be.
Yes.
Okay, so it's interesting then, the Sixth Circuit in Ritz in the Jackson Masonry case, creditor, they having this litigation's been going on, state court breach of contract lawsuit. The creditor wants to get relief from stay. The debtor files, obviously stops with the stay, the state court litigation. Has to do with breach of contract, and bankruptcy court says no, not going to lift stay. They don't file within 14 days.
Right.
Gets denied appeal, goes up to the Sixth Circuit. What does the Sixth Circuit hold, and what was their test? I mean, it's an interesting case. It's really one of the First Circuit cases where the judge really tried to hash out thoughtfully and break down, here are a couple of elements, and here's why, and so on and so forth.
Well, let me say one thing first.
Yep.
Judge Thapar, who's the author here, was the first President Trump nominee to the Court of Appeals, and he was on the short list for the Supreme Court. Now,
I did not know the latter part. That's interesting.
yeah, so he'd been considered for that role. But the court here, let me just set the facts a little bit, because I think that's important.
And they
here.
are.
You have a motion for relief from stay to go back to state court in Tennessee where the parties have been fighting over a contract dispute. And so the court denied it, and then denied the motion for relief from the automatic stay. And so the court then holds that it has to be, it's a final appealable order, has to go up now, and if you don't, you're going to lose that right. So
how would you, Judge Lee, how would you characterize, the Sixth Circuit said basically, this denial of lift stay motion is final because what
you have a procedure.
it's a proceeding.
Yes.
Okay.
Proceeding and that's defined under the bankruptcy code. You have,
which is clearly correct. Right.
You have finality in Judge.
What's the finality aspect?
Well, he believes that the denial itself concludes the litigation. It's over. And with respect to these particular facts, it may very well be.
Now it's interesting. I was, reading the Sixth Circuit opinion and looking at what's going to be going up to the Supreme Court.
Right.
I mean, it's interesting because you think, and I know Bill Rochelle talked about this in State Wire. You think about the nature of state litigation, and it varies a lot. Right. I mean, we were talking before. I think I filed so many lift stay motions on behalf of secured creditors. Often, if it's ones under 362 D2, early in the case, bankruptcy court may just say, well, because the necessary for an effective reorganization, sort of the feasibility point, they're like, well, we're going to give them some time to figure out what their plan is. But
I've given that speech so many times.
Exactly.
Right.
So if you deny, so you have secured creditor comes in, wants to lift stay, files a motion, and you say, going to give them some time. Can they appeal?
Well, there's a potential they could under Rosen. I mean, if it's big enough facts, if it's bet the farm or bet the business case, it may very well be.
This is where the second prong, I think, changing parties' status quo or substantive legal rights.
Right.
What are the legal rights? In this instance, it was a
Yes.
contract claim. That legal right is unchanged.
Yes.
And fast forward,
Yes.
they're an unsecured creditor no matter which way you cut it.
Right.
Versus,
Right.
sort of as the Solicitor General put in their amicus opinion, lifting the stay sometimes may allow the creditor to go out and attach a lien or perfect a lien. That would, by the denial of that, change the substantive right, because then all of a sudden you're converting from an unsecured creditor to a secured creditor. This is an interesting question because I don't know what substantive rights were changed.
But you can always annul the activity that went on.
That's right.
Yeah.
That's right.
But it's interesting. I think it'll be interesting to see what the court does, and we'll have to wrap up here in just a second, because one of the, as we all know, one of the interesting things about bankruptcy litigation is it varies, and it's not always like exactly the same. It's not like general civil litigation. It could be. I think you're right, Dan. I think there's a good argument, and maybe this is one of those, facts make bad law. I don't know, because you feel like it was kind of final there, but the kind of case I'm talking about, and what you said, were you giving that speech, you don't feel like it's final, because the really dispositive issue, I mean, of course the collateral's necessary, just like how feasible is their plan? And like week one, they haven't the foggiest idea what their plan is, but 6 months from now, they say, we still have no idea. Okay, at that point, we're going to lift state.
Right.
Yeah.
But the Rosen Group case is interesting because Judge Lepar cites Colliers, and he says there are all the circuits are aligned on this. You got the second, the third, all the big ones are seventh, all say that lift of state is
let me
the
ask you
final
this,
appeal
Judge.
board.
They do. If you're the judge, how can you save the creditor here? What kind of order do you enter?
I think it changes the landscape significantly, because now you're going to be with prejudice or without prejudice, which is not. It's going to really ramp up what lift from stay
Or
litigation
alternatively,
looks
you're
like.
going to get a lot of interlocutory or appeal. Just
And that's
to
what's
protect
happening in the Sixth Circuit.
And that's interesting.
Right.
After this, that's what's happening in the
Exactly.
Sixth Circuit. Well, Judge Hopkins and Dan, that's all the time we have for today's show. And thank you so much. I appreciate the engaging discussion. We remind our audience the archive of past episodes at abi.org. Until next time, this is Charles Tabb reminding you to elevate your understanding and keep your eye on bankruptcy. Thank you both.
Thank you.
Appreciate it.
Stay tuned for a live Q&A with our panelists.